What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. I wanted to go over this lawsuit that happened some time ago, but I think that the facts in the lawsuit are relevant to some of the things that debt collectors might be doing today. And what I call this video is a little technicality can go a long way in getting, being able to help you get out of a situation with a debt collector. Now, this debt collector, which is well known, Messerli Kramer, out of Minnesota or Minneapolis, Minnesota, what happened is they had attempted to collect the debt on these two individuals. And what they ended up doing is the United States District Court, I think it was FTC, ended up doing a lawsuit against Messerli Kramer. And I want to just read so you can kind of see what ended up happening, and you might think that this is kind of strange because this probably happened to you if you had a debt collector, and you don't even know that this is something that's illegal. And I'll admit that the way when I was reading through this, the way that the debt collector handled stuff, I think that I've seen this over and over again from different debt collectors. So we'll first start here, and this individual is actually from my city. Uh, and Messerli Kramer does a lot of buying of a lot of debt that they want to collect here in Wisconsin because it's a state, neighboring state. So we have right here on or about March 8th of 2017, Messerli faxed an employment verification letter to is that Sarnecki's employer, U.S. Department of Housing and Urban Development, Milwaukee, HUD. And it said here, and they had Exhibit A, we'll get to that. It said, upon information and belief, the alleged debt that Messerli was attempting to collect by sending a exhibit, which is the employment verification to the plaintiff, was allegedly incurred for personal, family, or household purposes, namely a personal credit card account. Exhibit A form facsimile cover sheet with the information specifically for her and this employment verification request inserted manually. It says that Exhibit A printed on Messerli uh, attorney letterhead, which identifies the firm as attorneys at law. Exhibit A also stated that the information in the fax message is attorney privilege and confidential information intended for use of the individual or entity named above. And then it had Exhibit A was addressed to attention HR/payroll department, U.S. Department of HUD, Milwaukee. Any employer receiving a fax cover sheet from an organization identifying itself as attorney at law that contains important notice, the communication is from a debt collector, is an attempt to collect a debt, would understand that the employment verification is being made in connection with a collection of debt. So it's about to get interesting. So please follow. So I'm just going to say she, I'm having a hard time saying that name, never gave Messerli consent to disclose the existence of any alleged debt in communication with her employer, in communication with the alleged debt. Upon information and belief, uh, Messerli, Messerli, whatever it is, did not have the express permission of the court of competent jurisdiction to disclose the existence of any alleged debt in communication with her employer in connection with the alleged debt. On or about March 30th, 2017, Discover Bank in Messerli, PA, filed this is crazy because Discover Bank will usually hire, so care of, they don't even buy the debt. File 17-SC, which is the small claims court, on or about June 20th, 2017, the court entered a default judgment. So you're probably wondering, where is this leading to? Remember, a little technicality can make a big difference. All right, so on or about July 10th, 2017, the court sent out an earnings garnishment notice in the court case uh, with the uh, with the U.S. Department of Housing and Urban Development as the garnishee. Exhibit A was sent to the plaintiff's employer for the case, even uh, was even filed, and long before judgment was entered, any post-judgment remedy could be effectuated. Upon upon information and belief, Messerli would have filed the lawsuit without verification of her employment. So here we go, right here. This is the technicality. And remember what what I had said in other videos is that a debt collector cannot threaten to take you to court and sue you if they don't plan on doing it. And the technicality that got this dismissed and ultimately got uh, this debt collector sued, even though when they do this for Discover Bank, Discover and American Express, they will hire debt collectors to collect it for them. They don't sell it to them normally. But what they did is they did a employment verification, because if she was not employed, they were not going to file this lawsuit. And that's the technicality, is that the violation in the Fair Debt Collection Practices Act is that they cannot threaten to take you to court to sue you if they are not really intending to do it. And just because of the way that they did this here, where they did an employment verification first, just to find out if she was employed. And then once they found out she was employed, they were like, oh, we can collect the money. And then what they did is they went ahead and got the lawsuit. And then you can read here, I'll put the link to this lawsuit. You can see that where they had explained that she had to, take time off work, gas mileage to meet with an attorney about this matter. So that little technicality, and I talk about it a lot, uh, but I had really never thought about it in that order. Okay, now, so let's look at this next letter, the meaner letter. It says on or about June 15, 2017, Mesler mailed out a debt collection letter to Meaner, and a copy of the letter is attached as complaint exhibit B, and we're going to get to those in a minute. Upon information and belief, the alleged debt referred in exhibit B is an alleged Capital One, and look at this, alleged Capital One credit card account used only for personal, family, or household purposes. Upon information and belief, Exhibit B is a form letter generated by computer with the information specific to Meaner inserted by computer. Exhibit B was the first written communication that Mesler sent to Meaner regarding the alleged debt identified in Exhibit B. And they have to send the letter first. They cannot call first. Also, on or about June 15, 2017, Mesler mailed a second debt collection letter to plaintiff. A copy of the letter is attached uh, to the complaint as Exhibit C. So they mailed a second debt collection letter to the plaintiff. On or about June 15, 2017, they sent a second letter. It's kind of confusing there. Upon information and belief, Exhibit C is a form letter generated by a computer with the information specific to plaintiff inserted by computer. Exhibit C attempts to collect the same alleged debt as Exhibit B. The amounts are the same in both letters. Sending a consumer multiple identical letters on the same day without alerting the consumer that the letters are duplicate is misleading and confusing. Look at that. This has happened before. This is a technicality, but this happened before. The practice may, for example, lead the unsophisticated consumer to pay the same debt twice. So there you go. That's technicality. Failure to provide the correct validation notice within 5 days of the initial communication with plaintiff and the class is a per se violation of the Fdcpa. And they have, I guess this was a lawsuit that had went down in the past. You can look that up. We have not extended the implicit material requirements to reach claims under, and in 169, this is under the Fair Debt Collection Practices Act. The Fdcpa creates substantive rights for consumers. Violation causes injury to consumers, and such injuries are concrete and particularized. And this is some more information here. Congress established an enforceable right to truthful information concerning debt collection practices, a decision that was undoubtedly influenced by congressional awareness that the intentional provision of misinformation related to such practices contributes to the number of personal bankruptcies, to marital instabilities, to the loss of jobs, and to invasion of individual privacy, which is something big right here that I talk about with the invasion of your privacy. This is one that I use in all of my court summary responses, is the invasion of privacy. Who gave them permission to have your information, number one, and then to share it even with the law firm that's doing these? Is that number one, that they don't expect individuals, number one, to be attorneys or lawyers. They just expect us to, if we get a piece of paper that's saying something that we might owe, number one, that we have a right to dispute it. Number two, if you get two documents, that it can cause confusion. And they know that people get into emotional situations when they get information from a debt collector, so they wanted to protect people. So now let's get to the exhibits that they had. Just take a good look. Here's Exhibit A, and it shows the was the HR documentation. Says 3-8, and that was before the suit. So you got 3-8 for the employment verification, and we got up here where they sent it. It was on 3-8, and they sent it on 3/30. They filed a lawsuit on 3/30. So they were within the 30 days, but they did it the wrong way, where they exposed the information to the employer before they even had a right to do that. You have to get a writ of judgment to be able to do that. And then this was just the bank information. Here's the one for C, where they sent the two letters. So we got Exhibit B. They sent this letter June 15th. And then they sent this letter again June 15th. But let me tell you another problem with this one. And this is probably why this happened. And this is a violation, that they cannot have companies, they cannot hire a company to send out this letter. And I'm pretty sure what had happened was they had a company that they hired, and they submitted these duplicate letters on accident, but that's a violation. They're not allowed to have a third party company produce a letter. They have to produce these letters in-house. Now, this is something I want you to pay attention to, which is a lot of people, when they get the debt collection letter, they only pay attention to this stuff up here. But right here, you can see important notice concerning your rights. And it says that this communication from a debt collector and is an attempt to collect that any information obtained will be used for those purposes. And this is just to scare you. Unless you notify us within 30 days of receipt, after receipt of this letter, that the validity of the debt or any portion of it is disputed, we will assume that the debt is valid. And also the law regarding the Fair Debt Collection Practices Act gives them the legal ability to place that information on your credit reports. So you got to let them know right away. And then it says that we will obtain verification of debt or a copy of a judgment against you and mail a copy of such verification or judgment against you. If you notify us in writing 30 days after this notice that any portion, the debt or any portion is disputed, we will obtain verification of the debt or a copy of a judgment against you. This is very misleading that they have this word in here at this point, because what most people think about this, if you don't read it the right way, and they use this word right here, we will obtain verification of any debt or a copy of a judgment against you. Uh, they should, I believe that they should have to change this, because the person can read this and they're going to they're going to get the verification to say that it's your debt and get a judgment against you. That's just the way that if you're reading through this, not in the right frame of mind, you can mistakenly think that they're going to be getting a judgment and that it's pertained to you against this. What they're really meaning is that the judgment that is potentially already against you for this particular debt. So they're very confusing on the way that they're stating this. So you can see that that's what they have for Exhibit C, and then they had resent this letter again with the exhibit. So I'm going to end the video here. Hope this is some good information. Please review it. You can always use these videos to find technicalities that might be where a violation with a debt collector that you're dealing with. These little bitty technicalities can make a huge difference. All right, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different. You can see my 8-point validation system or process and my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com. The links to all of those pages are below this video. And don't forget about my debt collection letters. If you need those, you can get them. The links are below here. My cease and desist collection activities letter, statute of limitations letter, and a debt validation letter. Make sure that you subscribe to my channel and hit the notification bell for new videos.